Hi everyone, it's November 17th, 2021, 6 p.m. Pacific time. I'm here with you, immigration lawyer John Khosravi of the JQK Immigration Law Firm, taking your questions live for general educational purposes. Just talk about, the U.S. immigration system and what's going on and how we can help and give you some guidance on that. If you're interested in having a private consultation, you have to email me at info@jqqlaw.com and you take it from there. I have a great guide called the Ultimate Marriage Green Card Guide. If you go to marriageimmigrationlaw.com, the website to download that free PDF for the Ultimate Marriage Green Card Guide is marriageimmigrationlaw.com. Check that out. It's going to help you a lot to figure out what's going on in the system. And also for those tuning into our live program, we give out 3 free 15-minute video consultations. Usually there's a hefty fee to have a consultation, but for those live watchers, we have a lot of regulars. Just like and subscribe and comment and say consultation, and my wonderful assistant Kayla at every 10 minutes. So at 6:10 and 6:20 and 6:30. You're a different time zone, so it might be different where you're watching. But in 10 minutes, 20 minutes, 30 minutes, I'll name off lucky viewers who will be able to, get a free consultation. Happy to do it. Just you know what to do. Say like, subscribe, and comment. Say consultation, and we'll take it from there. So with that, let's get it started. All right, everyone. So as people are trickling in, we're gonna get some questions popping up as we do every week. Doing this for over a year and a half now. Started with COVID and still going. COVID's still going and the Q&A is still going. So we'll see which one ends first, but probably we're gonna be pushing this forward. I enjoy coming on, rain or shine. I try not to miss any of these Q&As. I don't think I have ever. Maybe one will happen because of politics, let's put it that way. But, I like coming here talking with y'all, just feel you know what's going on. Every case is so different, and really the core of immigration is because people are so different, their paperwork is always going to look differently. But with that, the officer that's going to be interviewing you or reviewing your documents are going to be different too. So frequently, we'll have 10 cases where they all go the same, and then the 11th case, exact same thing. One officer will go a different direction or ask questions that are unexpected or want kind of documents that are not even necessary for the kind of case that they have. But they want it and they ask for it, and then we have to provide it. So that is a situation that we have to deal with today. I had an interview and a lot of unexpected requests for documents. We were able to get them all. The client was really good with document collection, so we had them all, we provided it. But they didn't make a decision. So, we want the case to be done, but now I have to wait a little longer for that to happen. So this is just the nature of the game. Mohammed asks, is it better for F1 students, or visa students, to register for selective service? It's not better or worse. As a student visa holder, you cannot sign up for selective service. It's not a requirement, so you shouldn't even be doing that. Selective service, for those that don't know, is the conscription system in the United States, the draft. So, U.S., if they go to war, they need to bring people on. And it's a requirement that if you're between, I think, 18 and 26, you have to sign up for it if you're a citizen, if you're a green card holder, or if you're in the U.S. out of status or violation or illegally or whatever. But if you're here lawfully in a non-immigrant status, like a student visa, you're a citizen of another country visiting here, and you don't need to and should not sign up for selective service. But if you somehow you get a green card, become a green card holder, you fall out of status, then no, you're gonna have to do it. You have to sign up then. But right now, as a student visa holder, not a good idea. You shouldn't sign up for the selective service draft. Thank you for your question, Mohammed. Special occasion asks, hi John, if an NOA, notice of action, this is and biometrics notice came together. So immigration lawyers don't use terminology like NOA because it's not descriptive. So if you say your NOA and biometrics that it came with one letter typo, I don't know what you mean by NOA. Do you mean the receipt notice? Do you mean like the appointment notice? But let's just say whatever it is, that issue is that they came with one letter typo in the address, last letter name of the street was wrong, both delivered successfully. Should I do anything about that? You could correct USCIS using their online system, but if that's not too much of a error, making a big fuss out of it could make it for confusing. So technically, I have to say you always want to have the correct info and update them. Whether you want to do that and bother and potentially create more confusion, it's going to be a personal decision whether you want to go with that. But do look into your paperwork and see if you wrote it down wrong, so you can mention it at the interview or some other place. But it's going to be your decision if you want to do that. I understand the hesitancy to do it. I have cases where USCIS on their own misspells clients' names on the receipt notices, and we contact them like 3, 4, 5 times, And they say we corrected it, but they still send stuff with the wrong name on it. So even if you try to correct it, it might not be correctable because they just don't get to it. Miranda asks, we are moving to a different location in 1 month. Should I wait to apply for I-751 using my new address? The reality is whenever you move, within 10 days of your moving, you're supposed to update USCIS to the change of address using online form AR-11. And so that's the rule. Now, that's it. So if you moved, you gotta do it. Now there's a situation where USCIS may mail you something and then like a week before you move, and then you move, and by the time it gets to you, it goes to the old address and you might miss it. And that's not something you want to do. And that's one of the good things about having a lawyer, is because your lawyer also gets a copy of everything. So if you want to time it a little bit, maybe let's say your new place allows you to move in earlier than the lease agreement starts, for example, then change it earlier if you have the address and you're going to be moving in sooner. You kind of got to play it by ear on that one. Special case follows up, can Postnup affect an I-751 and 400 applications? For those who don't know, Postnup is the agreement made after marriage has happened about distribution of assets and money, all this kind of stuff. I never ever bring up a prenuptial agreement or postnuptial agreement in any USCIS situations. It's not on the form, it's not a requirement, and frankly I think it has nothing to do with anything. If they ask, you got to tell them, but it doesn't matter in my opinion, so it's not something I bring up and I've never brought up in all my career. I'll be doing another regular ask, hi, how can I use my lawyer's copy for my biometrics since I'm not yet to get my copy? Well, your lawyer can scan a copy to you and you can print it out, or he can mail you the copy he has. As soon as I get my version of the copy, I take a scan, I throw it away so I don't keep the originals. I have a case actually where I got the appointment notice for the biometrics and the client didn't get it, so I sent him my scan of it. And then like 2 days before the actual date, he got the original in the mail, so you're probably still gonna get in the mail. But he was going to take the copy I sent. Now most locations will accept a copy. Every once in a while we'll have an officer or just an employee that says no, we can't accept copies, which is really incorrect. It doesn't make a difference, it's the same. So ideally you'd have an original, but if your lawyer kept them, have them mailed to you, or wait a couple more days, you'll probably get it yourself, or just take a copy and hope for the best. Probably gonna work. Gurpreet asks, can I expedite a work permit request filed based on marriage? You could always try to expedite your work permit. You have to have a reason. There's expedite requirements listed on USCIS.gov for various reasons. And if you match one of them, you have documentation, you could always give it a shot to try to get it faster. Yeah, why not? It's probably not going to work, to be honest. It's very tough, but you might as well give it a shot. Why not? Sepid asks, is it okay to travel with extension stamp and passport and expired green card? Well, I'd have to see your passport, I have to see your green card and see the extension stamp and know about your background. So I can't tell you whether something's okay or not. That's individual legal guidance, which I can't give. But generally, if you have the extension stamp for your green card in your passport, that could be used as evidence of, that is a green card essentially. And so you could travel with it, but I can't give that guidance to you because I don't know anything about you other than this one statement and your screen name. So there's a limitation to have where I can advise you, but generally that's how it works. But whether it works in your case, I don't know. A Wolf asks, I was on valid OPT when I applied for adjustment of status through marriage to a green card holder in June 2021. OPT expired after that, and now I'm under authorized stay based on my pending application. That 1 of 4, I think I have some more comments coming up. I had a case this morning where the interview just on this. Now me and my spouse are unofficially separated. Ooh, I'm heartbroken because I gave it all our marriage, but I need to be prepared as I know she'll withdraw application. Yeah, you're in a pretty bad situation. Let's read 3 and 4 if you type it out. My questions are, when the application is denied, will I accrue unlawful presence retroactively from the day my application expires? Okay, so no, unlawful presence, some lawyers say it is retroactive. From what I've read, it's not retroactive. So once you get a decision notice, especially because you're on duration of status, so definitely it's not retroactive. You're a student visa holder, there's no end date to your I-94, it's your part of duration of status. So you accrue unlawful presence on the date that the decision is made on your adjustment of status application. You can eventually be put into removal proceedings. Who knows how long that'll take, but it's possible that you'll be put, and they're supposed to put you in removal proceedings. Whether it'll happen and how long it'll take for that to happen, I don't know. It varies drastically. And if I leave the country right after denial, will I be able to enter the U.S. with a B visa I have? Can I shift to any visa to maintain my legal status since I'm applying for green card immigrant intent? So it's going to be hard for you to really do anything. This just goes way too much into individual legal guidance, so I can't speak more on that. But most likely it'll be very difficult for you to be able to enter the United States again whether you can change to other status or not, I need to know more information. So it just gets into way detailed and individual legal guidance. So I'll have to leave it at that. The gist of it is that, the short of it is that you're in a bad situation. It'll be hard for you to stay and come back, but there may be exceptions. So that's why I don't want to say for sure something like that, because I just don't know enough about you. Sorry about hearing about your relationship, but you should talk with immigration in private immediately. I don't really focus on this kind of case because there's some options you may have I don't want to discuss here, but you want to talk with a lawyer that handles that other option. So definitely consult with some immigration attorneys to see about that. For example, if your spouse was abusive or something like that. I don't handle cases where a spouse is abusive, but if they were, that could be a problem. Hossein asks, I got a green card through Asylum. It's been 4 years. When can I apply for citizenship? Well, look at your green card, and it has a date. That's the start date on the green card. Around 5 years after that, you could file for U.S. citizenship. When you get your green card through Asylum, the day you get your green card is not going to be the issue date. They backdated for 1 year. They should do that if they didn't make a mistake. So you automatically get 1 year of time on your green card. So it's 4 years essentially after you got your green card. But that's generally when you can apply. Now, I don't know your background and what you've done and where you've been, all this kind of stuff. So I can't say when you could apply, but that's generally the situation if you have an asylum-based green card in the timeline, unless you've been married to a U.S. citizen living with them or something like that. Now, I've been asked, I applied for EAD and I-130 together. That's a work authorization travel permission. And I got my I-130 a month ago, but EAD is something to worry. I'm not sure. Usually they issue the work permit, and the advanced parole travel permission for I-131 is listed on the work permit. So if you got the travel permission but not the work permit, it's not something regular. I've frankly never ever seen that happen before. I've seen it where you get the work permit once. We get a work permit and then a month later getting advanced parole, but this scenario, I've just never seen it happen. Sometimes these mistakes happen. You contact USCIS to see what's going on. Sam asks, hi, Mr. John, thank you for your time. You're welcome. What's your experience about applying for N400 before 90 days on 3 years? Do you have an issue about 90 days and foreign passport requires N400? What else? Well, I can't get too specific on what's needed for your case, but I'm not sure what you mean by before 90 days on 3 years. So at the earliest you could file is 90 days before the 3-year mark if you've been married and living with a U.S. citizen. Now, if you do it before, they're going to deny the case because you filed too early. And what's required, I mean, the foreign passport is not required with the form. A copy of the front and back of your green card is. You will need to bring your passport or passports, right, previous ones that show travel history on there, with you to your interview for naturalization, but I don't send passports with the initial filing. If you're married, for example, you want to send your marriage certificate. If you've been divorced, you want to send divorce certificates. If you've been in the military, you need to send military stuff. Hopefully when you got your green card, you had mentioned military stuff, so it's not the first time it's coming. But it just gets deeper and deeper depending on your situation. But don't file before at least the 90-day mark if you have everything else in order, because that's going to lead to a rejection. Or the initial person, the mailer gets it, will start the case, you'll wait 6 months, a year, and then you go to your interview and they're like, oh, this was filed too early, you're denied, you wasted time, you wasted money. So just be patient and file when the window opens up. User 22 asks, we have our interview scheduled for next month, but we never got a work permit. Yeah, the work permit department is so backed up that for most of my cases, my clients never even get the work permit. They just have their green card interview and the green card's issued. These are like, adjustment of status, mostly marriage cases. The work permit system is just such a hot mess that the field officers themselves are working faster and getting the interview. So that's a normal thing to happen. Wave asks, can I travel if I apply for N400? I don't know if you can do it. Generally, the F400 doesn't mean you can't travel. You can't stay out. There's still the requirements for continuous residence, so you could do a vacation or something. But I don't know if you could do that or not. I don't know anything about you. But generally, the F400 doesn't stop an applicant from being able to travel. Zelk asks, is I-751 still coming in mailbox? New for 24 months? Thank you. Well, one thing that's happening is for I-751s, these are removal of conditions. When you have a 2-year green card, usually through marriage, and you have to get a 10-year green card, this taking so long for the government to approve these that people are left all of a sudden without a valid green card. So what they originally did is they said, when you file your I-751 case, you get an automatic 1-year extension, and the receipt notice that comes with it that shows you started your I-751 case will say automatic 1-year extension. And then it kept taking longer. They made it 18 months. And then about 2 months ago, they said, okay, when you file your I-751 case, we'll send you a receipt that says automatic extension of your green card for 24 months. You have that paper as a special paper with your green card that's expired. You use that for work and travel, all this kind of stuff. Now what's happening is had cases where we filed before they made this decision to give an automatic 24-month extension. But all of a sudden, like last week in the mail, I got like 10 different receipts for cases I'd already filed months ago, where they just sent new receipts showing the 24 months. So there's new mail coming to hook you up and give you 24 months extension instead of the 18-month extension to hold you over, because I think they're expecting huge delays in I-751s. Having said that, I have I-751s completed in like 5-6 months, some 8 months, 10 months, and some 2 years. Super duper inconsistent when it comes to the timeline of I-751s. But with regard to your question, we are getting receipts again in the mail, which is kind of weird at first. Like, what's going on? Then I saw, oh, they're sending updated receipts to show the 24-month extension instead of the 18-month extension. and why they might put me in removal proceedings if I leave right after denial. Again, thanks a ton for your help. I know I'm in a terrible situation. My spouse won't even talk to me. I'm really sorry about that. So if you're out of status, they'll put you in removal proceedings. So if you leave, you left, they probably won't, but they might not know you left. They'll think you're still here. So they'll send you a letter saying come to removal proceedings. So it's a mess. So if you know your case is going to get denied, why not leave beforehand and notify USCIS that you left, send a letter or something like that? Probably safer. Keep track of the information that you left in the United States, like your ticket, any stamps in your passport. So if you need to fight it later and show that you did leave, you have evidence of leaving. So for example, when you go to your home country, many times your home country won't stamp stuff. And so they don't stamp entry stuff. Try to get them to stamp it so you have evidence that you left. Okay, special case. Based on your practice, how much harder is it for people to sponsor a marriage-based green card and they sponsored a person for it before? It's not necessarily harder. I see people do it all the time. And so it's not too crazy. But it depends on the case. Like, when were you married? What evidence of the previous marriage? Does it look like fraud happened? It depends on the case. It's not something I can say based on experience, because it really depends on your unique case. It's not based on experience. I've got these approved before, but it's facts intensive. So it doesn't matter what my experience with other cases are. Really, it depends on what's going on in your case. Mindy asks, I'm unmarried, over 21. Would it be better for my parents to sponsor my green card if they are citizens, or would they be the same green card? If you're unmarried and over 21, it's better they file as green card holders, not citizens. It's a year faster. You're not allowed to get married. If your parents do become citizens after they started your case, and then you get married, the case will stay. You'll just go into a different category. But if your parents stay as green card holders and you get married, that destroys the case. So that's a side topic. It's not what you asked. But essentially, if you have a parent that's a green card holder, it's faster by a year to have them apply for an adult unmarried child than a U.S. citizen filing. That's just the way it works. So it's better for your parents to file as soon as possible before they become citizens. For everyone else, I know we got a ton of questions. It was a good question day, but we're all done. We'll see you next week, same time, 6 p.m. Pacific time, Wednesday. Try to get in early. We'll get your questions in. And thank you so much for everyone for listening. I really enjoyed doing this. Unfortunately, all the questions can't be answered. Some of them that we got to, they're just too hypothetical or not enough facts. I gotta be careful of what I say. I don't want to give bad advice, so I have to be very cautious of that. But thank you so much for asking anyways. I wish you all the best. God bless, be safe, and talk soon. Bye-bye. I hope you enjoyed this educational video. You'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.